Good afternoon. My name is Kathleen Miller. On behalf of the Maine Women Writers Collection, I would like to welcome everybody to today's Donna M. Loring lecture. We stand here together today on Wabanaki land. This land carries the stories of all the people who have inhabited this place. Part of healing the wounds between us is to listen. We are grateful to you, Ambassador Donna Loring, for opening today's lecture, and to you, Chief Francis, for being willing to speak with us today. Thank you to everyone who made time to be with us. Welcome to those who are viewing this event online, via streaming or via Facebook Live. I want to begin by acknowledging the people who helped to make this event possible. First of all, thank you to Jennifer Tuttle, my other half at the Maine Women Writers Collection, who unfortunately couldn't be here today. Thank you to the Department of Environmental Studies for co-sponsoring the event. I am grateful for the help of many people, Laura Taylor, Callie Gurley, Erica Rousseau, Lee Cody, who has been my personal cheerleader since this event was canceled in October. I extend my deep gratitude to all of the behind-the-scenes people in facilities, catering, and AV who truly do make these events possible. Thank you. And thank you to the President Herbert for being here today. It means a lot to us that you're here. I'd like to remind everyone just to silence your cell phones if you haven't already. And now I'll introduce Donna Loring and say a few words about the lecture, and then we'll get on with the talk. As many of you know, Donna Loring is Penobscot Nation tribal elder and held the position of the nation's representative to the Maine state legislature for 12 years. Among her many accomplishments in that capacity was her sponsorship of the act to require the teaching of Maine Native American history in Maine schools, which has begun to address an urgent need in our education system and the culture at large. She is also the author of In the Shadow of an Eagle, a tribal representative in Maine, and is the host of Wabanaki Windows on WERU. Ms. Loring is president of Seven Eagles Media Production, a nonprofit whose mission is to eliminate cultural bias and institutional discrimination against the Wabanaki people through supporting the accurate representation through media of Wabanaki culture and history. In 2001, she was recognized by UNE with a Deborah Morton Award given to outstanding women who have achieved high distinction in their careers and public service and who are exceptional leaders in civic, cultural, or social causes. In 2009, Ms. Loring deposited her personal, professional, and literary papers to UNE's Maine Women Writers Collection, a special collection on the Portland campus. In acknowledgement of that gift, the Donna M. Loring Lecture at UNE highlights issues of concern to Native people in Maine and beyond. We view it as an opening, as opening a clearing where the community may participate in some of the conversations that are necessary to move toward healing the deep wounds created by colonization. It is an extension of Donna Loring's ongoing work and an important part of UNE's educational mission. It's now my privilege to turn the podium over to Donna. Thank you.
Thank you. And thank you for attending. I know the food was really what you came here for, right? I would really like to thank President Herbert for attending. Appreciate that. So, the keynote speaker this year is Chief Kirk Francis, and you're all aware of the River case. And, we've had an ongoing adversarial relationship with the state of Maine since the beginning. And it's always been my view and my thought that a lot of things could have been taken care of outside of court if the state of Maine would just recognize our sovereignty our tribal government, and just talk to us in that respect. And that's never really happened. I'm not going to belabor things because I know Chief Francis has a lot to say, and I'm not going to take away from his time. So, without any further ado, but I do want to say that he has to put up with me because I'm on tribal council too, that he's the longest serving Penobscot Nation chief, elected chief, since 1850. And he was elected in 2006. And for some reason, I don't know why, we keep electing him. So, Chief Francis.
So you get a snapshot of what those council meetings are like. And, but I really do want to acknowledge Donna. I mean, she's been a tireless advocate of the arts for Native students, and also through her writings trying to educate all people about tribal perspective on whether it's policy or history. And so another round of applause for her. And again, I think we're going to touch on a little bit about why the nation has an ambassador position today, but Mullion is serving as our first appointed ambassador. She works very hard, and you probably see her a lot around the state trying to address stereotypes and how mascots affect Native people, and really try to educate people overall about the importance of coexisting in a very respectful way. And she's a great diplomat for our tribe. So another round of applause for Ambassador Smith. And I also wanted to acknowledge in the crowd Maine gubernatorial candidate Adam Cody, who has been a great advocate for partnerships and friendships throughout Maine. And I don't know if there are any other candidates here, but are there? Hi. Hi, Terry. Excellent. Well, it's good to have you as well. And so, Adam and Terry, it's good to see you both, and thanks for coming. Before I get started, I just wanted to let you know, one, I forgot my glasses, so if I stumble around here a little bit, just bear with me. Also, I thought what we'd do today is really, rather than just focus on legalese stuff around the case, which is, or cases that have happened over the last 15 years, we will certainly touch on those, but I thought it was extremely important for us to also understand the foundation of these arguments in terms of where the tribe is coming from. We often hear from the public in terms of, why do tribes expect these special rights? Why do tribes, why are they always, in some cases, complaining about this? When all we hear through the media is, slot machines and jurisdiction and all of these other things, but they're really much deeper issues than that. And it's really about the tribes trying to regain themselves through self-determination in a very rights that have been granted since the formation of this country through the United States Constitution. So we're going to talk about some of those things, and also at the end I'm hoping that our dialogue can be more detailed to get at your questions. So with that, as Donna said, I'm the proud chief at Penobscot Indian Nation. I'm in my 4th term, and it's been a life-changing experience for me. As Donna knows, and everybody who governs knows, it's not always an easy job, and you have your days, and I think good public servants, though, are really people that thrive for those days when everything works, and then you see the results of your work on people, even though it's a profession that's often filled with failures. But I do appreciate everyone being here. So with that, good morning, and again, want to thank you for taking the time to participate in a dialogue with me about the importance of the Penobscot River to my people and its cultural identity, and how the continued attacks, predominantly by state government, on our rights in the river are impacting our cultural survival. Before I get into details of the current lawsuit between us and the state over the Penobscot River, I again think it's important to provide a brief perspective about the Penobscot Nation, our relationship with the federal government, and our relationship with the state of Maine. The Penobscot people have been on these lands of what is now Maine for thousands of years. Indian Island, which is the headquarters of our people, has been a part of our existence, again, for thousands of years. Today, the Penobscot Nation consists of about 2,500 members. We have total land holdings of over 160,000 acres, and our reservation is made up of 220 plus islands in the Penobscot River. A lot of people have a misunderstanding of the relationship between tribal people and the United States. The most common mistake is the belief that we were conquered. While it is true that some tribal nations were indeed conquered militarily by the United States, for the most part, tribal societies were not conquered. Yes, there were battles, but usually these were resolved through diplomacy and efforts such as treaty making. That is why the relationship between the United States and Indian tribes is a political relationship and not a racial one. And this is an extremely important distinction. You know, there are cases out there today that are trying to focus on Indian tribes being in a racial relationship with the United States, because if people can prove that, especially around things like Indian child welfare and a whole host of other things, then they can prove that relationship is unconstitutional. And a lot of the rights that tribes have to keep their children and a whole host of other things would go away. So again, very important distinction, and that distinction is memorialized in many ways throughout the history of the United States. So our relationship with the United States has really been defined by the structure of the federal government, the executive branch, United States Congress, and the U.S. Supreme Court, and the non-existence of any international forum in which to bring claims against the United States to be heard. The Constitution of the United States in 1787 mentions Indian tribes a few times. The most notable provision is Article 1, Section 8, which provides Congress the power to regulate commerce with Indian tribes. This is a significant provision because it essentially acknowledges that Indian tribes pre-exist the United States, and it establishes the political relationship as one that exists between tribes and the federal government. There is no mention of states, but only of Congress having powers when it comes to tribes. This power of Congress is further evidenced when, beginning in 1790, Congress started passing a series of 6 laws known as the Indian Non-Intercourse Acts. These laws basically prohibit the purchase of any Indian lands without the approval of the federal government, and we'll talk a little later about why that's important. The political relationship between the United States and Indian tribes was further cemented in the early 1800s in a series of 3 lawsuits that were decided by the newly formed Supreme Court. In these cases, which became known as the Marshall Trilogy, in honor of Chief Justice John Marshall, the Supreme Court established 3 foundational principles of the United States relationship with Indian tribes. The first was the adoption of the doctrine of discovery. This doctrine basically says that lands are not discovered until Christians discover them. The doctrine was basically used to invalidate, ignore Aboriginal possession of lands. Since tribal people were not Christians at the time, possession of lands did not necessarily have to be recognized. The Supreme Court used this doctrine to uphold the Indian Non-Intercourse Acts by deciding that although Indians were rightful occupants of this land, tribes had no power to sell lands to anyone without the approval, again, of the federal government. The second was the Indians were neither citizens of the United States nor foreign nations. Instead, we were domestic dependent nations, whose relationship to the United States resembles that of a ward to his guardian. This ruling set a legal precedent for the trust relationship in which the U.S. has a duty to provide certain benefits and services to Indian tribes. So again, getting at that question of why does this special relationship exist? Why do tribes, for example, receive federal program funding to run their programs? This is all about the trust fiduciary relationship. The third was the states had no authority over persons or actions within the boundaries of an Indian reservation, and state laws did not extend to Indian country. This ruling clarified that Indian tribes were under the protection of the federal government and that Congress, rather than states, had plenary authority over Indians. These three principles changed over the next century through acts of Congress and more decisions by the Supreme Court. But I mention them because it shows that although the federal government saw itself as the dominant government, it did recognize tribal nations as governments, and ones that were not subject to state authority. Most importantly, Indian tribes' right to self-governance were recognized early by the Supreme Court and continue to be recognized for the next 2 centuries. Today, most Indian tribes exercise self-governance, which is essentially the right of any group of people or society to govern itself free from outside interference. This includes the right to govern our people and our lands. Only in a few states, and unfortunately Maine is one of them, are there continued attacks on the basic right of Indian tribes to exercise this self-governance. Our relationship with the state of Maine today is governed by the 1980 Maine Indian Land Claim Settlement. This modern-day treaty was intended to enhance the sovereignty of the Maine tribes and promote self-governance and self-determination. But unfortunately, it's failed miserably. The Settlement Act was intended to resolve land claims brought by the Penobscot Nation and Passamaquoddy tribes against the state of Maine in the early 1970s for the wrongful taking of millions of acres of land, about 2/3 of the state of Maine. I mentioned the Non-Intercourse Act earlier in my discussion in how it was a federal law that prohibited the sale of Indian lands without federal government approval. It was that act that formed the basis for our land claims. Our basic claim was that the federal government, who had forced the Non-Intercourse Act upon us through court decisions that deemed us domestic dependent nations, had not approved the sale of our lands to what was then the state of Massachusetts and later Maine. Our claims were not taken seriously by either the state or federal government at the time. In fact, the Federal Department of Interior, who was supposed to be our trustee, failed to bring the claims on our behalf. We had to bring them ourselves. In 1975, the Federal Court of Appeals upheld our claims. At that time, resolving our claims became an immediate priority for both the state of Maine and the federal government. Having our claims validated by the federal court was significant. For the Penobscots, we finally felt like our voices were being heard. But the vindication of our rights led to panic by the state and non-Indian communities, who feared that they would be kicked off our land and chased out of the state. We never intended to do such a thing, but the backlash from the affirmation of our rights led to extreme racism and a very difficult time for our people. Ronald Reagan, who was then the candidate for United States president, said he would terminate the tribes of Maine before he would allow the lands to be given back to them. We didn't want all the lands back. We did not intend to kick any Maine citizens off the lands, but we wanted a land base for our people, even if it was lands that no one else was currently living on. And we wanted an acknowledgement of the past, the wrongs of the past. And we wanted some resources so that we could begin to mitigate the harms that had been done for us, or to us, through failed federal policies and bad relationships with the state. Most importantly, we wanted recognition by the state and federal government of our rights to self-government and the ability in self-determination. With these goals in mind, our leaders decided the best course of action for the Penobscot Nation and our citizens, and the citizens of Maine, was for the tribe and the state to negotiate the land claims settlement. Our leaders worked in an honest and transparent way to negotiate what we thought would be a fair settlement of our claims that would allow us to exercise our rights to self-governance without unduly burdening the state of Maine and the non-Indian communities. But along the way, negotiations expanded beyond land claims at issue in the court decisions to jurisdictional matters. And when the tribes objected to changes being made in the federal legislation that was needed to approve the settlement, the concerns of the tribes were ignored. Our federal trustee became more interested in the rights of the state. This led to some ambiguities in the Settlement Act, and the state has used every opportunity to exploit those ambiguities to expand state authority over the tribes and minimize any rights of the tribe. This is particularly true with respect to any rights we have to our water resources. The Penobscots understood the Settlement Act to recognize our right to govern ourselves free from state intrusion. We had seen provisions from the United States Senate reports describing the Settlement Act and including statements that said from this day forward, the tribes of Maine will be forever free from state interference when it comes to matters internal to their tribes. The reality for the Penobscot Nation since we entered into the settlement has been less than full of respect for sovereignty. Our right to self-governance has been under constant attack. Congress knew the Settlement Act wasn't perfect and changes might need to be made during its implementation. So it's evidenced by the fact that within the Settlement Act was the creation of the Maine Indian Tribal State Commission. This commission was created by the Settlement Act to continually review the effectiveness of the Act and the social, economic, and legal relationship between the state and the tribes. It was supposed to help resolve issues between the parties, but has been largely ineffective due to the state government's unwillingness to give due considerations to commission decisions and recommendations. The state government seemingly prefers to go into court rather than engage in a true government-to-government resolution process. In 2006, the tribe again reached its hand out to try to find solutions, and the Tribal State Work Group was created pursuant to an executive order of then Governor Baldacci. It was comprised of state and tribal leaders. Its purpose was to identify problems with the Settlement Act and focus on potential solutions to address them. From the tribe's perspective, this effort reinforced that this document has strayed from its original intent and has been used to try to turn us into the state's political subdivisions. After a 2-year process, a report was generated that outlined concerns with the Settlement Act and contained several recommendations for positive change. And although the tribes felt these recommendations fell woefully short of fully addressing the issues, we viewed them as a step in the right direction, and we participated in the process in good faith. The recommendations then went on to the State Legislative Committee of Jurisdiction, the Judiciary Committee. And however, in the end, not one of the recommendations were adopted by that committee. Our belief was and remains that the state, through its representatives, is simply not prepared to recognize us as true sovereigns. So the place where this has been the most devastational and where we've been most vigorously attacked on our rights is with respect to our water rights. We are a riverine people and have relied on the Penobscot River and its resources for thousands of years. And I mean, we say that, but think about that. Archaeology tells us, right, over 10,000 years, our people will tell you they've been there since time immemorial. And we have the oldest graveyards in our community, dating back to those 10,000 years. And it's just an amazing feat for a tribe like ours to have been in the same place forever. I mean, we weren't pushed there, we lived there, and we lived there for a very long time. And our people care deeply about the river. To us, it's a living entity. It's important to the health and vitality of our people, and our reservation includes the islands and the river itself. And more importantly, our way of life and cultural identity is tied directly to its resources. But for decades, the state has challenged any rights we may have in the Penobscot River. And unfortunately, the state's been winning, and our rights to the river have been diminishing. The state applied in the early 2000s to the Federal Environmental Protection Agency to obtain control over the issuance of wastewater discharge permits in the Penobscot River and delegate that authority to the state. Since such a delegation by EPA to the state would have significant impacts on tribal water resources, the tribes became involved in that and opposed this delegation of federal authority to the state, at least as it applied to reservation waters. So when we talked about the foundation of the relationship between tribes and the United States has responsibilities to tribes. We have a trust relationship with them. As our trustee, they're supposed to protect us. States have no responsibility to that, which was the foundation for our opposition on this issue. So you can't delegate the trust responsibility, you can't delegate plenary authority, so we felt like our protections would go away in an already very difficult jurisdictional arrangement here in Maine. So to make matters worse in that case, the paper companies, also very interested in this case for obvious reasons, through their attorneys and pursuant to Maine's freedom of access law, served requests upon the Penobscot Nation and Passamaquoddy tribe requesting access to tribal documents related to communications between the tribes and federal and state representatives about this matter. Now, I will also add that those documents could have been obtained by simply going to the federal government or going to state government as constituents of both of those. We felt like that would have been the appropriate process, not getting involved in internal tribal matters. So when the tribes refused based on their view that the state law did not apply to them because it was an intrusion on our internal tribal governmental matters, the company sued the tribes in state courts and won access to our records. So this is a huge blow to tribal sovereignty. And you know, when we brought the lawsuit in federal court challenging the federal delegation as well over wastewater discharge permits to the state, we also lost that case. The federal courts determined it was appropriate for EPA to delegate full authority to the state for all discharges, even those on the reservation. The courts concluded that the state has regulatory authority over all waters in the state, even those within Indian Territory. So with the strokes of their pen, the federal courts took away the ability of the Maine tribes to have a meaningful voice in how the water resources in this state are managed. Unfortunately, this example was only the beginning of a concerted effort to separate us from the Penobscot River. In 2012, the Penobscot tribe received a letter from the State Attorney General's office saying that our right to sustenance fish in the Penobscot River no longer existed, despite an opinion from that same office in prior years that it did exist. So why is this significant? Nobody really cares, I think, about who has a right to fish and where. But sustenance fishing, statutorily, is an indigenous fishing right, and it comes with it associated authorities under the exclusive jurisdiction of the tribe to protect that resource so critical to the cultural identity of that tribe. So it's more about the associated authorities and who gets to control what. So we had to protect ourselves in this issue, and we filed a lawsuit in federal court. Unlike in prior matters, when we asked the United States Department of Interior and Department of Justice to intervene in the case on our behalf, they actually did this time. And this is really significant. It's the first time that the United States has sued a state on behalf of a tribe in the Northeast that we can ever find. So it's very, very significant. It's not something the federal government takes lightly. As a matter of fact, they exhausted years of, 2 years at least, of communication with the state trying to find solutions and trying to get them to participate in a dispute resolution process that would find common ground on this issue. They're not crazy about suing states, and states have constitutional protections. But in the end, they did, on our behalf and on their own, citing federal law, Indian law violations in that case. And the absurd thing is that during oral arguments of this case, the state argued that, yeah, they have a right to fish, as long as they stand on their islands and fish from there. But we did not have any rights to fish on the water. the state argued that the tribe historically was not on the river, despite our reservation being made up of over 200 islands and encompassing over 65 miles in that river. So the state wasn't even willing in their oral arguments to acknowledge a riparian common law right of the tribes in their own land holdings within the river. So simultaneously, to make matters worse, while this lawsuit was pending, the state of Maine asked the Federal Environmental Protection Agency to determine whether Maine controlled all of Maine waters with the sole authority to set water quality standards. Unfortunately, the EPA ruled that the state indeed did possess this authority. However, the EPA also stated that Maine's water quality standards had to recognize tribal fishing and subsistence uses. Having the authority was not enough. Maine is now suing the EPA over this tribal protection in their decision. So just to back up a little bit, this environmental protection case, basically the tribe has promulgated its own water quality standards. We have our own water quality department, our own labs. We do the most testing in the Penobscot River. Matter of fact, we have an agreement with the Department of Environmental Protection with the state to provide those samples. So for us, it seemed like we should have some voice in how these water quality standards were being promulgated. And so this was all a result of Maine's water quality application under the Clean Water Act being denied by EPA due to 9 different criterias that either in the human health criteria range or just weren't significant or protective enough. A lot of them had nothing to do with the tribe, but 2 or 3 points did, and that's what they're suing the EPA based on. So, kind of out of vindictiveness at the time, and because of us invoking our federal protections, Governor LePage rescinded an executive order that eliminated the state's policy to consult with the tribes in certain matters. In response to this, and unfortunately, and it was a really tough thing for us and a sad day, I think, but because of the actions by the governor, the Penobscot and Passamaquoddy tribe, not just that action, there's a whole body of work that kind of led into that, but pulled our representatives from the state legislature after more than 200 years of having a seat in that body. So we simply could not participate in a state forum that refused to acknowledge our rights. So why does this all matter? Why does my nation and my people continue to fight for our rights to our namesake river and our water? Because it is critical to our cultural survival. When Penobscot people can't fish anymore, when we can't practice our customs and traditions centered on the river because of pollution or whatever it is, we can't be who we are anymore. And when you lose the cultural identity, we're giving up the God-given right for our children to be Penobscot. So that's the seriousness of these fights. It's not about who gets to control what. As a matter of fact, the tribe was very clear in the EPA decision. When the EPA said the state of Maine has the authority to promulgate water quality, but we're also going to protect the subsistence and sustenance-based cultural rights of the tribe, we backed off from that. All we care about is the river being protected and our way of life being protected. So, for Indian people, when we discuss sovereignty, we are talking about the right to self-governance again, to govern ourselves, protect our natural resources so our people can live for the next 7 generations. When we allow others to take that power from us, we lose the ability to protect our communities, protect our people, and just, like I said, to ensure the long-term survival of Penobscots. Our native communities have historically been some of the poorest in the state, with high unemployment rates, high substance abuse rates, high infant mortality, and a low life expectancy, which today is still unacceptably 57 years old. A key cultural resource of our people, the Penobscot River, has become polluted and full of dams. We have not been able to harvest the fish from the river for sustenance since 1985. It is demonstrated to us time and time again that when others decide things for us, it does not result in the best interest of the Penobscot Nation. So for tribal people, we have reached a point where we cannot compromise any further if we are to survive as a distinct culture with a unique contribution to this country. When we exercise more self-governance, our people and communities do better. For over 3 decades now, we have focused on increasing our ability to govern ourselves and become self-sufficient, and we are noticing positive improvements. Our housing conditions have improved. We have constructed numerous new houses on our reservation. We've built apartment buildings and assisted living centers so our elders can stay in our communities in those last years of their life. The Penobscot Nation has also constructed an assisted living center, as I just mentioned, and we offer meal service 5 days a week for them. We have our own healthcare system, providing medical, dental, nutrition, diabetes prevention, laboratory and counseling services, as well as our own pharmacy. We have also taken steps to improve our economic condition. As a government, we employ over 200 people. We expect our business development efforts to continue to grow significantly, to provide jobs and economic self-sufficiency to our people. We once again are encouraging our citizens to embrace their culture through language revitalization and many cultural programs. The tribe is getting back to recognizing the voice of our women, children, and elders, who have played a vital role in our history and so important to the prosperity of our community today. We are focusing on our educational systems, trying to create more opportunities for our people to attend some of Maine's best institutions to which we've had limited access to in the past. We have expanded our internal social programs to focus on cultural healing and emphasizing the elimination of dependency in any area. We have our own judicial system, featuring the tribal court, where our citizens are dealt with in a tribal environment, as well as our own public safety, warden service, and fire protection. All of these activities go towards self-governance and self-determination. We are providing for ourselves in our community because despite other people's perceptions or misperceptions of who we are, or whatever stereotypical images they may hold of tribal people, our communities are not looking for special treatment or handouts, nor are we interested in being perpetual victims. And many of our people do not ask for assistance at all. The Wabanaki tribes are comprised of great people, possessing great character, integrity, and responsibility, and only wanting what's best for their families and communities, like all of Maine. Our people care about this state. It's our homeland, and we are connected to it, no matter what any document or deed may say. We want it to prosper, but we must be an equal player in accomplishing those goals. It has absolutely been my pleasure to talk to you today as the proud leader of a proud nation. If you remember nothing else about this presentation, I hope you can take away that sovereignty comes down to one basic question of who gets to decide your future. And when that's taken away, it can have devastating effects. So thank you all. One person stand. You see that? And I'm happy to answer any questions as well.
Chief Francis, my name is Erica Russo. What can we do to advocate or help the Wabanaki to change the situation, to make it better, and to help your culture thrive?
One of the things that we've really recognized and noticed over the course of certainly the past 5 years, I would say a lot of these fights in the late 80s through the 90s through I think the tribe was truly alone on those fights. And I think what we've realized is the importance of relationships and coalition building and partnerships. And again, what our message is the Penobscot River is in this state for everyone. We recognize that. This is a state resource. And we're in a coexisting society. What we really are asking for is that within this territory, that the unique and distinct culture of a people be respected. And what you can do to help is continue to form partnerships with tribes through participating in letter campaigns, talking to your local representatives. We realize this has got to be a citizen-driven initiative. It can't be solved politically. We've been trying to do that for, a few hundred years. And I think we have very good people in Augusta that I consider my friends who work really hard to try to solve these issues. But what really Augusta and any government listens to is the people they represent. So I think it's important to keep communicating what you expect as a Maine citizen in relation to the state's relationship with Indigenous people, and that we find a more productive way to move forward.
Hi. Oh, hi. Are there other precedents in other parts of the nation where tribes have sued about these same water issues?
Yeah, I mean, water rights is a huge issue nationwide. I mean, there are cases going on right now all across the country on tribal water rights, especially around subsistence fishing. Washington State comes to mind, for example, right now. So yeah, this is a big issue for tribes. The challenge we have here, and what makes it more challenging for the Maine tribes, is the ambiguities in the Maine Indian land claim settlement. So for example, a tribe in a state without a land claim settlement can seek treatment as state or treatment as a sovereign and promulgate their own water quality standards within their territory, and they don't have to ask the state for anything. You see states doing a lot of that tribes doing a lot of that type of activity across the country. The Maine tribes get a little bit, have this other layer of challenges they have to get through to kind of deal with those. But to answer your question, yeah, tribes and water rights and water resource issues remain one of the top litigated issues around Indian country. And yeah.
Thank you, Chief Francis. My question for you would be, might there be a different opportunity for this conversation, given that we're not making any paper on the Penobscot at this point? Does it change the potential for a different dialogue?
And I think it has. So to be fair to the conversation, we've had a $65-70 million river restoration project where the state was a partner in that, along with a whole host of other people. I don't think that happens, 20 years ago, 25, 30 years ago, with industry peaking at that time. So we're very grateful at the restoration project. Also, a lot of the fisheries work that's going on, and et cetera. So I think there is an opportunity from that perspective to not have that type of pushback from industry within the river. But, as we stand here, we're still under a fish consumption rule. Pregnant women aren't allowed to go near it. There is different levels for youth, and then so it's well below, the Wabanaki exposure scenario, which outlines the consumption rates for Penobscot people. So I do think that makes it an easier conversation.
I might as well take advantage of the opportunity. So, Chief Francis, imagine for a moment that Maine's next governor is in the room.
Mm-hmm.
What does he or she, what's the takeaway for he or she under those circumstances? Given, I really appreciate the history and the overview. A lot of us don't understand those details, but what would you have us leave with from that perspective?
Just let us do whatever we want. No, it's like, but in all seriousness, I think we have to create mechanisms. I mean, I think a governor as well is also, there's a lot of moving parts in state government. So the governor can be very much a champion on these issues and make things a lot easier. But I think what the state really lacks is any structural mechanisms within state government that deals with the complexity of these issues. So you have for example, you have a Senate Committee on Indian Affairs within the federal government. You have House Natural Resources. You have these bodies within Congress that are challenged with the expertise of the relationship with Indian tribes. And it's not always perfect there, as we know. I mean, but here we don't have any of that. We have nobody that works on Indian affairs within the administration. We have a judiciary committee that's tasked with jurisdiction over this relationship that, and it's not discrediting, it's just not the work they do. And it's much more complicated than simply, a gaming issue. Well, that issue, for example, and I'm not saying, we're even thinking about that these days at Penobscot, but our thing was always a fairness issue around that. When we have federal laws that protect our right to move into that economic arena and really alleviate a lot of poverty and create a lot of jobs, and that is, the Indian Game and Regulatory Act is really an act that was built for states to ensure their partnership in these things. But, so our point with all of that stuff is, and I can go right down the list with the Violence Against Women Act we've been obstructed against, the Stafford Act amendments, the inability of us to even declare disasters on floods on our own lands because the governor thinks that somehow that's his authority and he doesn't want anybody else doing that, even though it would be more efficient and the tribes would have to pick up the cost share, not the state, on those issues. So, again, it's a long list of things, but I think to your question is we have to have a more informed conversation as governments and get away from who's controlling what and really focus on the meat of what the issues are, what the histories are, and why it's so important, and have a structural setup that understands that.
I was just going to add that when I met with Chief Francis last year, I asked the same thing, Terry, and I was looking at it and I thought there was going to be, coming in twice the unemployment rate, child mortality, the life expectancy, all of these issues, economic development problems. And I asked the question to Chief Francis, and his immediate answer was one thing: a seat at the table. Such a small ask, right, in so many ways when you think about it. And at the state level, there just isn't that dialogue. And Chief Francis is a very humble man, and to ask just a real basic piece like that, it's just such a sad state that we're in right now with the relationship the way it is. So thank you for being here, really. This is incredible for all of us.
I just want to ask what you see as the next steps for the Penobscot Nation and in the river case.
So where the case stands is we're currently asking for a review of the First Circuit decision from the First Circuit, which is called an en banc hearing. We are represented by a very good firm that works diligently and has a lot of expertise in this area. We've been represented very well up until now in building our core arguments. Our next steps are to wait and see kind of what the First Circuit is saying. We think we have basic Indian law principle arguments in this case in terms of the tribe in no document ever says we're ceding the Penobscot River. The understanding is throughout the Indian law community and federal Indian law policy is if you never cede it, you never give it up. And tribes get deference on that. So, again, we're always dealing with another layer of issues with this Settlement Act and, some islands-only language that gets argued to mean we must have meant only islands. So So I think the next steps, for us are to wait and see kind of what the First Circuit says. But I will tell you, I think, I feel fairly comfortable speaking for the tribe that we're going to go until there's not another court to hear us on this issue. And when I was talking about, you know, that cultural identity piece. I mean, this is really a termination case for us. And that sounds maybe dramatic, and when we use words like genocide, but that's the very definition is removing the cultural identity of a people. That's the very definition of genocide. And it's one of them. And so that's the importance of this. It's not about controlling the Penobscot River. It's not about controlling people. It's about being able to protect a way of life that ensures that we're still here. And I think Maine losing that unique and distinct culture within its borders with so much history would be a shame for everyone.
Thank you, Chief. I was just wondering, how do you address amongst your people the rage and the despair and the loss of hope after so many centuries of bad faith negotiations and disappointments and just sitting through this brief talk you've given, I feel enraged. I'm just curious how you address that amongst the youth of the tribe and really anyone.
You know, well, one, if you've ever been to Penobscot, the message getting relayed usually is coming from them to me, and they're one of the things that I'm amazed with our tribe is, and you see this all through Indian country, but even after all of these setbacks and defeats, and I'm really proud of our tribe and where we are. You know, we run 110 programs. We're one of the largest employers in our region. We have beautiful lands. We have cultural-based activities. We just have a really good situation, I think. And but if we're truly going to overcome, you know, 1 in every 3 of our women being sexually assaulted by non-Indians, if we're going to overcome, you know, a close to 30% unemployment rate, if we're going to overcome a lot of those things, health disparities where we're at 22% diabetes rates in the community, if we're going to overcome those things by being able to really create programs to deal with them through resources and through our own authority, then we're just not going to get over them. But we talk a lot about just staying the course, being who we are, and being proud of that. We know that we stand on the moral high ground of these issues. We know that decision making isn't always about right and wrong, and we need to figure out how to get people to right. That's all. And I think it does us no good when we talk about not interested in being perpetual victims. We're just not. We have too many talented people, and we're going to just keep plugging away. And if it wasn't for that spirit in our ancestors, none of us would be here today. So.
I had a question. You were talking about EPA getting total control over waters in the state of Maine. I thought in the land claim settlement that it was really clear that waters of a certain size, ponds of a certain size, were to be controlled by Penobscots and Passamaquoddies. Was that taken away with that, with the EPA decision?
No, there is. So they define the waters. Some of them are on reservation. Some of them are on trust land. So we've always understood the Penobscot River and still understand it to this day to go through the reservation. So so there are different definitions that deal with different bodies of water. So this case really is about the river.
Yes.
And so and one of the things I wanted to add too in the thing is that the United States being involved in this case is really significant. And a lot of people worked hard to make that happen, but it spans 2 administrations that couldn't be totally more different. Right, and that isn't happening on a lot of things. So I think the fact that they've stayed the course, continue to see the injustice here and stuff, is really indicative of what's going on.
Thank you, Chief Francis. My name's Mike Johnson, and I wonder if you could say more about the Violence Against Women Act. I know about what had happened when it was created, but just wondering what's happening lately.
Sure. So when VAWA was reauthorized in 2013, they recognized this this condition within Indian country in a very disparaging way of numbers of assaults, who they were being assaulted by. So we know through our statistics that 85% of victims of domestic violence on an Indian reservation, those are being committed by non-Indians. And what was happening was Indians haven't had jurisdiction over non-Indians within their communities. So many times, for example, a victim come in, we'd have these great programs, cultural-based programs, and the ability as a smaller community to be able to holistically deal with her. And it's mostly her, unfortunately. I think the governor was right on one point. This is really kind of a man issue. And I think that the point of Congress was that we need to develop a local response to deal with a local problem to have success on this. So what they allowed is for tribal courts to prosecute non-Indians in certain domestic violence situations. And the funny thing about the act, too, is it says that nothing in this act preempts state jurisdiction. It removes double jeopardy. The state could still get involved if they wanted to, all of that. And so when VAWA was first reauthorized, they had a period where they were going to do some test pilot sites. And we were one of 7 tribes being considered for that. And the Attorney General's office wrote to the Department of Justice and objected to it. And they objected to it based on saying that we have a unique relationship under the land claim settlement, and they had the authority over VAWA-based cases of non-Indians. And justice never allowed the pilot program to move forward here, even despite the fact that our chief judge, I mean, we've had judges leave our bench and they're on the Maine Supreme Court now. We have a chief judge that does all the training, the VAWA training for tribal courts all across the country. And so we felt very capable to handle that, provide all the constitutional protections for defendants, and yeah, we haven't been able to execute jurisdiction of VAWA because of the state's objection to that. And by the way, that condition still exists. So.
Thank you, Chief Francis. My name's Catherine Rhoda. I'm wondering that, assuming that whoever is the governor of Maine actually has a practical significance in these matters, what questions would you urge those of us who are concerned citizens engaged in looking forward to the primary process be asking of the candidates? I mean, is it a matter of asking if they're willing to reopen the land claim settlement, or what other questions should we be raising as concerned citizens?
Well, I think 2 things. I think one, they ask what their commitment is to all Maine people. You know, what is your commitment to all Maine people? You know, what we've seen a lot of, and this is my own political view, and I don't, but we have this kind of war on the disadvantaged going on, right? And it's becoming kind of chic to do that, both here and at the national level. And so I think the basic question is, how are you going to represent all of Maine, from our most rural communities to the cities in southern Maine, right? And that includes the native communities in this state. How are you going to enhance the relationship with Maine's Indian tribes? And see what their understanding is of that first, of what that relationship should be. And I think, yeah, and you know, I just think, again, there's an educational process to be fair to everyone, but we need candidates that are committed to these relationships and that are committed to cures. And I do think that saner heads have to come together at some point and look at that land claims document after 40 years. I don't know if there's been a treaty in history that's lasted 40 years in its entirety. But to say, you know, are we dealing with the realities of how today works in this document, when we're trying to deal with so many things that, you know, we have an opioid crisis, for example. Didn't have that in 1980, but yet the tribe can't exercise provisions of the Tribal Law and Order Act to prosecute higher drug crimes in our court, for example. So does the Settlement Act need to be looked at? It does. It's a highly political issue when raised, but I think, you know, we need people with the political will to take these issues on. And so, yeah. You have that will, is that what you're going to say?
Chief, how
Hi.
you doing?
Hey, Ben.
I just was going to ask about, as far as particular legislation, let's say for sustenance fishing, could anything be done on the state level outside of the Settlement Act? Or would it require the state amending the Settlement Act and then the federal government having also to sign off on it?
I think if it's in the Maine Implementing Act, we have the ability to make those changes here in the state. Obviously, changes to the federal legislation will have to go through Congress, but I do think there's a lot of things we could do. I think 1735B, for example, we often talk about, that talks about the tribes' federal beneficial acts not automatically applying here if they're outside of internal tribal matters and they preempt state jurisdiction. Those two definitions often get blurred, as we know, on these issues, but that one provision in the that's in the federal portion. But I think if the state and the tribes came together and asked for change on that, then we're talking about access to the Clean Water Act. We're talking about having conditioning and real authority around relicensing. We're talking about, and when I say authority, I mean a voice and a vote in those processes. And so, so I think there are things we can do. We could, you know, when you look at the 2006 work group report, 200 and something pages long, a lot of these same things we talk about today, you know, 12 years later, were recommendations we were making back then to address those foundational issues. So to your question, yeah, I think there's a lot we could do through legislation. The will was there.
So, Chief, my observation is that, at least in the last 7 years, our Attorney General, the current Attorney General, and the current Governor agree on very little.
Mm-hmm.
But they seem to agree that the Wabanaki people pose some kind of threat to the rest of us relative to these legal issues. And it might suggest that our elected officials choose our Attorney General. So there may be an opportunity to have an impact in talking with your local elected state rep and state senators around that choice, because that individual makes decisions separate from the governor. You know, the Attorney General doesn't work for the governor at the governor's behest. I think that's pretty clear to us, but somehow there seems to be a partnership here in an unlikely place. So there may be another avenue for folks to have an impact down the road.
Yeah, I agree, and I'm glad our issues could bring them together. It's good.
Hi, my name is Sarah. I'm a student here, and kind of just coming off from the perspective of a student, like I am like very interested to kind of see if there's like any programs or like community events that you guys have that bring in people that are non-native, non-Indian to kind of enhance that like community-based interaction and understanding, because I think that's like really essential. Like I didn't even know that sexual assault statistic that you brought up. So like, are there any like programs or events that kind of bring that into effect and like bring that into the conversation and the dialogue? And if there is, could you talk about those?
Sure. So yeah, we have a lot of, well, first material that can be accessed through curriculum training that we've developed through our Cultural and Historical Preservation Department, but also during our community days, weekends, we invite anyone to come. We have vendors there from all our programs that are doing education materials about the issues they're dealing with, et cetera. On the second day of community days, we have a cultural-based event. It's more of a pageant type thing where we invite a lot of the outside community to come in as well. And I would just say that to your question, and certainly if you want to get us your name, we can get folks to communicate with you about any information you may be seeking, yeah. So we have a very open community in that regard.